I'm Mark Crewman, Director of the Center for the Study of Citizenship and Chair of the Department of History here at Wayne State University. I'm delighted that you've joined us for our annual Citizenship and Constitution Day program, focusing on the very controversial Citizens United decision made recently by the U.S. Supreme Court. The center, if you've been watching things swirl around on the screen above, you have gotten a glimpse of the kinds of programs that the center sponsors. It is the global leader in the study and promotion of citizenship, conducting research in the community nationally, sponsoring the International Conference in Citizenship Studies every year on campus. And international does not mean that we get a scholar coming over from the University of Windsor. It's been a marvelous experience, working to build the center with so many colleagues across campus and in the community. And before I hand over the microphone, actually I'm going to put the microphone back up there, to our moderator, I do want to invite you back on October 25th for the Center's Corporate Citizenship Symposium. Our keynote speaker will be Mickey Maynard, who just recently left the New York Times. She was their senior business correspondent, and she's now heading a Midwest project for NPR. Mickey will be talking about the impact of foreign companies on the American economy and on American society, and it'll be same time, same place, but a very different but equally exciting subject. Now it's my great pleasure, first of all, to thank Dean Ackerman and the law school for its sponsorship of this evening's program. The law school has been, from the inception of the center, a wonderful partner in developing activities and programs in collaboration. A number of members of the law school faculty, as we have tonight, have spoken at center events, and it's wonderful to have an institutional partner like the law school and a law school with such a distinguished dean as Bob Ackerman. So thank you, Bob. Also, thanks to the Irvin D. Reed Honors College and to the Eugene Applebaum Chair in Community Engagement for its support of this evening's program. Our moderator this evening is Linda McKissick-Beal, who teaches tax law here at the Wayne State University Law School. Those of you who attended our Corporate Citizenship Symposium last year, which Linda moderated, probably came back to watch her in action again. She did such a marvelous job that I asked her to reprise her role this evening. Linda is a distinguished tax attorney and has a famous blog, and which means that she's hip, and but she's also very interesting, very smart, and she's going to introduce tonight's topic, which I've sort of semi-introduced already. All right, I'm talking too much.
Linda, I would never say that, Mark. Welcome, everyone, to this Center for Citizenship and Constitution Symposium. As Mark has said, this year's symposium is centered on Citizens United, just in case you don't know what that is, that was a First Amendment case decided by the Supreme Court this last January, and it created both, I guess, waves of jubilation and shockwaves of discontent, depending on where you were on the spectrum about the issue. To introduce the symposium, I thought it would be worthwhile to note two things that Justice Kennedy said in his opinion. He makes two very bold, from my perspective, statements about corporate speech. He says, the government cannot restrict political speech based on the speaker's corporate identity. A very absolute, point-blank statement about restricting speech. And he says, there is no sufficient governmental interest to justify limits on the political speech of nonprofit or for-profit corporations. If you have read the opinion, you know that he goes through several subcategories of ideas and proposals connected with each of those statements, and I'm sure we will have further discussion about them in the course of tonight's lectures. I just want to point out, as someone who frequently teaches corporate tax and therefore have not infrequent occasions to think about the role of corporations in today's society, that we Americans seem to be of two minds when it comes to judging what a corporation's role in society should be. To some, the corporation is a single-minded money-making machine that should do anything and everything to advance its profits for the benefit of its managers and shareholders. It owes no allegiance to the country. In fact, it is in some senses quasi-sovereign in that it can and should move its assets and work to whatever jurisdiction offers it the best deal, with no remorse whatsoever for empty, decaying factories left behind or workers fired and left with inadequate or non-existing pensions, for communities hit with a declining revenue base. This is expressed, in case you think I'm exaggerating and taking a stereotype out of the air that doesn't exist, this was expressly expressed in a sandhill.com blog posting in 2007, in which an officer of a multinational corporation said the following, and this is a quote: "Companies have no moral or ethical obligation to do what's best for America or Americans," skipping a few words. "Multinational corporate executives only have one obligation: to increase shareholder value. If offshoring will improve a company's bottom line, then so be it," skipping a few words. "Job loss that may result is irrelevant." He goes on to say that corporations should pit countries against each other and profit from, and this is a quote, "the spoils of war." So that's one view of corporations that exists in our society. To others, corporations have an obligation to a variety of stakeholders, not just to their shareholders and managers who most clearly enjoy their profitability. They have an obligation to employees, communities, and the government that creates the stable system that allows them to do business in the first place. The example often used is the fabric mill in New England that stayed open at the expense of the owner in order to provide continuing jobs to its employees during tough financial times, even if it meant less profit to the owner and avoiding selling out the business to a foreign, low-cost labor country. Academics have addressed this as social responsibility of corporations, but it's not a mainstream, yet, theory of the corporation. Now, if the theory of the corporation is the stakeholder theory that views a corporation as having a social obligation to the community, we might feel one way about Citizens United. If the theory of the corporation is the shareholder value theory that views a corporation as appropriately profiting by creating wars between jurisdictions, we might have another view of Citizens United. So setting the stage in that way, I hope, with sort of the polar extremes of our views towards corporations, I now want to introduce our speaker, who will talk to us about this decision, which is viewed by the ACLU as a victory for First Amendment proponents. We'll have about 45 minutes for that discussion, and then we'll have presentations about 10 or 12 minutes from each of our panelists, and then we'll have some open audience participation. I would like to introduce Joel Gora, who is our keynote speaker. a professor of law at Brooklyn Law School, who teaches in the area of constitutional law, election law, and civil procedure. He has advised the American Civil Liberties Union for many years, and he's worked on landmark cases in the campaign finance area and other areas. He was a part of Buckley v. Vallejo, which, as some of you may recall, was a '76 case that dealt with spending as speech. He's the author of a number of articles and several books dealing with constitutional themes, from rights of reporters, due process of law, the rights of protest, and a recent one on a realistic proposal for campaign finance reform. Without further ado, and without taking any more of his time, let me invite Professor Gora to the podium. Thank you for coming here.
Thank you very much, Professor Beal, for that introduction. I did, as Professor Krugman say, come all the way from Brooklyn. I weathered a rainstorm in Brooklyn and a rainstorm in Detroit, and I'm delighted to be here to help celebrate the birthday of our Constitution. And I want to thank Professor Krugman and the Center for the Study of Citizenship for inviting me to participate in this event, and also to say how delighted I am to share the platform with my former Brooklyn Law School colleague and friend, Professor Steve Winter. And I also want to express my appreciation to Professor Robert Sedler, my former ACLU colleague and my friend, for whom I have the highest regard. And thank you, Professor Beal, and I look forward to your participation as well, Dr. Okoti Ibo. I come all the way from Brooklyn, and I come from a slightly different perspective on the issues than I think Professor Beal does. And if you'll allow me a time to try to develop that perspective, it'll perhaps be a better idea of where I'm coming from. We celebrate tomorrow the 223rd birthday of our Constitution, which I think is still the greatest document for governance ever fashioned by human beings. As a lawyer and a teacher, it's been my privilege to have labored in the vineyards of constitutional law since my first law school summer internships with the ACLU and the NAACP. But what specifically brings us here tonight is not my biography. It's the Supreme Court's decision in Citizens United versus Federal Election Commission. To my mind, it was basically a very simple case. Maybe I'm simple-minded. The First Amendment to the Constitution says that Congress shall make no law abridging the freedom of speech. In the McCain-Feingold bill enacted in 2002, Congress did that. It prohibited all corporations and all labor unions from broadcast advertisements near an election that simply mention the name of a federal candidate. And it is the court's duty, it's referred to it as its painful duty, when it has a law which it feels violates the principles of the Constitution, to declare that law unconstitutional. And of course, that goes all the way back to Marbury versus Madison. But I gather that not everybody agrees with me that the court made the right decision in the Citizens United case, and the reaction to the opinion, of course, has been extreme in many ways on all sides. So I'll try to state my case a little bit in a little bit more detail. My own involvement with these issues began quite some time ago when I was a young ACLU lawyer, and three people came to our office. This was during 1972. Richard Nixon was president. He was a candidate for re-election. And these three dissenters had run an ad in the New York Times. It was pretty costly, too. They came up with the money. They ran an ad in the New York Times criticizing Nixon and saying that he ought to be impeached. They got a visit from the Justice Department. The Justice Department wanted to know who they were, where they got the money from, and why they ran the ad. And they asked the Justice Department why these inquiries. And the Justice Department said, well, we have this new federal campaign finance law, and it basically regulates anybody who does things for the purpose of influencing the election. You criticize the president, it's an election year, and therefore we want to see why you're not complying with that law. They came to visit us at the ACLU, and quite frankly, we were stunned. The idea that you couldn't run an ad in the New York Times criticizing the President of the United States without getting a visit from the government asking why you were doing it and who you were and where your money came from and why hadn't you filed proper reports and things of that kind, suggested for us what has been true ever since is the tension between campaign finance restrictions and First Amendment rights and principles. And that's what the court has had to deal with ever since. And that's what the court dealt with in the Citizens United case. Citizens United did not deal with any of the kind of corporations that Professor Beal mentioned. It dealt with a nonprofit corporation, basically an ideological corporation, that had put out a movie critical of Senator Hillary Clinton while she was running for president. Because it mentioned her name, they were barred from running ads for it on television, and they also wanted to put it out on video on demand, on cable, and they were barred by the McCain-Feingold law from doing that as well. And so when the case came up, it seemed to me that it was basically the same as those three old guys that had come into the ACLU 40 years earlier. People wanted to use their resources to put out a message critical of somebody who was the President of the United States or wanted to be the President of the United States, and the government was imposing the campaign finance laws to say you can't do that. Or you can't do it unless you do it in a certain way. You can't do it under certain, unless you do it under certain conditions. So that's how I and Professor Beal referred to the ACLU. That's how we got involved in these issues back with those three old guys. And it took us into the Buckley case, and the Buckley case involved efforts by Congress to restrict the amount of money that people and individuals and groups could spend communicating about politics. And it seemed to us that those limits on the expenditures were limits on the speech, and that there was no good justification for it. The court basically agreed with us and said that the government, Congress, state, local, can't limit how much you spend on politics, how much you spend to get your message out. Whether you're a candidate or an independent group, the government can't limit that. And the issue that came in Citizens United is really a very similar issue. What's the justification for limiting the ability of this organization to speak out about a candidate for President of the United States? So Buckley not only held that limits on expenditures for political speech were violative of the First Amendment, but it also said that particularly when the speech is independent of the candidate, it's not somebody that's connected with the candidate, it's an independent group or an independent individual, that speech is really in a way the most important speech under the First Amendment. It's citizen speech, citizen advocacy of different points of view, and it should be entitled to the greatest protection. And so those were the benchmarks that Buckley laid down. Limits on expenditures are impermissible, and particularly on independent expenditures. In my paper, I have a long disquisition on the path that the law has taken since then. In the interest of time and not wanting to subject you to cruel and unusual punishment, I will spare that disquisition. But I will basically say that the court, 2 years after Buckley, had a case involving a corporation. The law in Buckley limited everybody, including corporations, but honestly, the discussion in the Buckley case was really focused on individuals and groups of individuals, although corporations are groups of individuals. That's what Citizens United majority said. But 2 years later, there was a corporation, I think Gillette Company or some big First National Bank of Boston. They wanted to speak out on an issue about whether to have a sales tax, whether the people in Massachusetts should enact a sales tax. And they were restricted from speaking by state law, and the Supreme Court said even though they're corporations, they want to speak out about politics, they have the same right as anybody else does. So there you had Buckley, which said that you can't limit speech about politics or the funding of it. And there you had Bellotti 2 years later, which said, and that includes when corporations are responsible for that speech, when it's coming from corporations, the people that run the corporations. That seemed to us pretty clear you couldn't do that. In 1990, in a case coming up here out of Michigan, the Austin case, the court majority, in effect, said otherwise. Said, well, there's something so potentially pernicious about the money that corporations have and its ability to distort the political process that it's okay to restrict the speech of corporations about candidates. Maybe you can't restrict the speech about an issue on the ballot, but about candidates you can restrict corporate speech. Well, the ACLU was on the other side of that case, and we were quite disappointed in our loss because it seemed to us that Buckley and Bellotti had said one thing, and then Austin had said the opposite. And although Austin said you could limit corporate speech because all the wealth that corporations can amass can threaten the electoral process, it sounded very much like an argument that had been rejected in Buckley, that you could limit one person's speech if he or she has more money than somebody else to level that playing field, to equalize and make sure nobody spends or speaks more than anybody else. And in Buckley, the court said the idea that you can limit your speech because you don't have as much is foreign to the First Amendment. The First Amendment is designed to ensure that everybody gets as much speech as they possibly can. So it seemed to us there was a tension between the Buckley-Bellotti positions and the Austin case. And the tension only got worse when McCain-Feingold came along in the McConnell case and said not only could corporations not say vote for Smith or vote against Smith, but corporations and labor unions. McCain-Feingold was bipartisan. It restricted the speech of both corporations and labor unions, and not just business corporations or conglomerates or multi-conglomerates, but the ACLU and the NAACP and the Sierra Club and every other nonprofit cause organization in America, which is a corporation. So the statute that was at issue in McConnell, that was revisited and struck down in Citizens United, made it a crime for any corporation of any size or shape, of any background, of any orientation, and any labor union to engage in any speech that even mentioned, it's almost like it was, you can't say that, even mentioned the name of somebody running for office within the election season. So something had to give. Either the speech would be allowed or the speech wouldn't be allowed. A lawsuit was filed against the McCain-Feingold law in the early 2000s, McConnell versus Federal Election Commission. The plaintiffs included an alphabet soup of organizations from the ACLU and the AFL-CIO on one side, joined by the Chamber of Commerce and the National Rifle Association, groups across the political spectrum, saying you can't do this. Congress can't limit the ability of all of these institutional entities to speak out about members of Congress during an election season. The ACLU said, we want to run ads in October telling Congress to pass a bill telling Bush to stop torturing people. But we can't even run an ad saying, call Senator Schumer and tell him to vote for the bill, because we've mentioned Senator Schumer, and he's up for re-election. So viewed from that perspective, that kind of a sweeping statute restricting the speech of millions of organizations. I mean, there are millions of corporations in America, probably hundreds of thousands of labor unions. Every one of them was restricted by this law. So we joined a group to challenge it. The Supreme Court, in my view, to its discredit, 5-4, upheld the law. The theory was that a lot of the ads that might be sponsored by corporations or unions or ACLU or what have you might influence the election, and the candidates might know who ran those ads, and they might give them too much access and too much influence, and therefore the court said it's okay to have this blanket across-the-board restriction. Well, that was 2003, and the court changed a bit since then. And it's always interesting to teach constitutional law when the law changes in a brief period of time, and the changes seem to track some changes in membership on the court, and you're trying to convince your students that it's a government of laws and not of men and women. But nonetheless, the replacement, in fact, of Justice O'Connor with Justice Alito has clearly had a real impact on campaign finance cases. Whereas Justice O'Connor, who interestingly in that Austin case with the Michigan statute, she was with the dissenters. She was with the ACLU. She thought it was wrong to limit the ability of corporations and unions to, so in that case, spared unions, only corporations. It was wrong to limit the ability of corporations and unions to speak out. She thought it was wrong. She changed her mind over the period of time, and so in McConnell, 2003, she was the 5-4 majority. She was replaced by Justice Alito, who has shown more of a suspicion of campaign finance laws, that they are not necessarily designed to seek the good government that's claimed of them, that they're designed to perpetuate the power of the people in power. They're designed to make it harder to criticize them and harder to throw them out of office. That it's designed to protect incumbents and to protect them against criticism. Now, it's kind of like two ships passing in the night. That's what I view these laws have as their purpose and effect. Other people think they're designed to keep the beast from devouring democracy. So it really is two different perspectives. Well, those perspectives came clashing again together in the Citizens United case. But as I said, in the last few years, in a couple of other campaign finance cases, the court had shown an impatience with some of the restrictions, a willingness to look at them more closely. The court in McConnell that upheld McCain-Feingold showed a great deal of deference to congressional judgment about how to regulate political speech and what political funding might cause too much influence and access and corruption and the appearance of corruption and those kinds of things. But the court now seemed less inclined to give that deference, to view the congressional judgment not as deferential but as suspect. Not as trying to improve government and politics, but as trying to protect themselves against challenge and insurgency. So those views came to clash again. And again, remember what the case was about. A nonprofit corporation, not a big, bad global conglomerate, a nonprofit ideological corporation wanted to run a movie critical of Senator Clinton, a candidate for election. The Supreme Court says in the opinion, what more important thing can there be a First Amendment for than to allow criticism of somebody that's holding themselves up to be President of the United States or to be reelected as President of the United States? So to my mind, the case was the hardest case to justify restrictions on speech. And indeed, a majority was not willing to justify those restrictions. Part of the problem was that the case was argued twice. In the first argument, in the spring of 2009, during the discussion and the hypotheticals, like we all do in law school classrooms, somebody said, well, this is a broadcast, but if it were a book that advocated the defeat of Senator Clinton or criticized her candidacy, would the government have the power to regulate the publication of that book because it came from a corporation? And the government's lawyer's answer after some fumbling and fancy footwork was yes, it would. That the government's power to regulate corporate speech includes its power to regulate the publication of a book critical of a presidential candidate. And I think that's why there was an audible intake of breath in the courtroom when that answer was given. And I think that's why the five-person the majority that had become pretty skeptical of campaign finance laws thought, oh my God, we've got to rehear this. And they heard the argument again in the fall of 2009. And the same issue was asked then of Solicitor General, now Justice Kagan. And she gave the same answer, although she said, well, we've never really proceeded after a book. And someone said, well, what if a corporation printed out some pamphlets, you know, like 1787 and all that? And she said, well, that might be a different case. So in other words, the power to regulate corporate speech was thought to include, or was not disclaimed to include, the power to regulate pamphlets printed by a corporation, or presumably a labor union, or any other entity that the government sought to regulate. So those were the issues and the setting in the Citizens United case. And the arguments for limiting the corporate speech. And by the way, the reason this group was a nonprofit corporation, but they got some amount of, modest amount of money from business corporations, just like a lot of other organizations do across the political spectrum. And because of that, they were not able to claim an exemption as a pure nonprofit corporation. But some of the theories for regulating corporate speech don't really depend on the nature of the corporation, be it a profit or a nonprofit. They depend on the fact that it's artificial, it's an entity. So let me just briefly identify the sort of 5 key arguments for why it's okay to restrict corporate speech about politics, and give you my take on some of them, because the court, in one way or another, or the larger community, the court of public opinion, has been wrestling with those issues, and I just want to touch upon them briefly. The first argument is basically what I call the impersonation argument. corporations don't have free speech, only people have free speech. Well, of course, the First Amendment doesn't say that. It says Congress can't restrict the freedom of speech. We've given corporations all kinds of constitutional rights for a century or so, including First Amendment rights across the board. Corporations are really aggregations of people, just as unions are, just as the ACLU is, just as all the organizations are. And the speech that is generated by the entity is really the speech of the people that comprise the entity. So the notion that somehow only people have free speech rights and not corporations, that ship sailed a long time ago, and that Rubicon was crossed a long time ago. And in this modern complex age, it's almost impossible to get your message out without joining together with somebody in some fashion, and usually forming an entity, often a corporation, to do so. And so I think the impersonation argument is not very persuasive to me. Then there's the distortion argument. This was Austin, and this was McConnell, the idea that corporate money can be so overwhelming that it kind of taints the whole process. Well, in Buckley, there was individual money, and that didn't seem to bother the court. And most individual money comes from corporations. And at one point, unless you won the lottery, if you're a millionaire, you're giving a lot of money to the ACLU or the Democratic National Committee or whatever it may be. It came from business activity. And so the idea that somehow it's evil when it's in the corporate treasury, but then when it's in your pocket, even though it came from the corporate treasury, it won't be distorting. And particularly since it sets up a dichotomy between certain corporations and other corporations. Most of the laws which limit corporate speech about politics exempt media corporations. And you maybe can make an argument that the press is different from speech, but I'm not sure it's a very weighty argument. And so you have a situation where if a business company, a widget company, runs an ad on page 25 saying so-and-so would be a good president, they can go to jail. But if the owners of the newspaper company write an editorial on page 26 saying so-and-so is a good president, that's protected by the First Amendment. To my mind, the First Amendment ought to protect both forms of speech from both sources, particularly in this day and age, speaking of conglomerates. When you have General Electric, until recently, I guess, owning NBC, you have a giant utility company owning a news medium. So are they a good corporation or not a good corporation? When NBC speaks, should we give it protection because it's the press, or not give it protection because it's owned by a large corporation? So I think those are some of the problems with the distortion argument. The corruption argument is that even though, remember, the speech is independent. It's not coordinated with any of the candidates. It's out there. It helps some candidates. It hurts other candidates. And the fear is that the candidates who are helped will be receptive in the future to the views and visits and things like that of the people that ran those independent ads. Well, to my mind, if the labor unions go out and spend hundreds of thousands and millions of dollars to ring doorbells, do all this stuff to elect President Obama or some other candidate of interest to labor, and then expect that that candidate is going to do things that are going to help labor, we don't view that as corrupt. We view that as political life and as a good thing. That people and groups are supposed to go out and get their message out and ring doorbells and do all that stuff and spend their resources to do it and elect the people that they expect will do the things that they voted them in office to do. Far from being something questionable, it seems to me that's the essence of democracy. So the idea that you'll somehow gain improper influence because you run an ad saying so-and-so is really good on labor issues, and then they get elected and you call them up and say, can I come talk to you about labor issues? That's corruption. Again, to my mind, I have a different take on that. So I think the corruption concern about corporations is questionable as well. Then there's what I call the extortion argument. Since the state creates and giveth, the state can taketh away. Since corporations are created by the government can set the terms and conditions of what they can say and do and things like that. Well, maybe for many purposes, maybe certainly for tax purposes, but for free speech purposes? I mean, when I hear that argument, I think about my youth and maybe Professor Winter's youth, when people who were communists and things like that wanted to be lawyers, and they said, oh, you want a license to be a lawyer? Well, you have to say you're not a communist. Well, but I'm sorry, I have a right to be a communist. Yeah, but you don't have a right to be a lawyer. We license you. Well, it's the same kind of argument, that because corporations are the creature of the state can control the speech of the corporations. I'm not sure we want to go down that road. Again, the ACLU is a corporation. Planned Parenthood is a corporation. I'm not sure we want to admit that, what I call extortion argument, as a justification for restricting corporations. And then finally, there's what I call the imposition argument, imposition on shareholders. Well, shareholder democracy is great, and it's been a very important movement, but it just got a big jump start after Citizens United. I mean, a lot of corporations in which I invest, I only know of one corporation that I'm invested in because I bought the stock myself because my sister works there, and she told me it's a good corporation. It is, and I have a few shares. But I own a lot of corporations through my TIA-CREF, thank you, pension. I don't know what they are. I don't know what stand they take on issues. I don't know if they give money to the Museum of Modern Art or the Metropolitan Museum. There are a lot of women and artists of color that think the Metropolitan Museum of New York is a terrible place because it discriminates against women and artists of color. And so should I be able to say to the Exxon Corporation or the Widget Corporation, before you can make a contribution to the Museum of Modern Art or the Metropolitan Museum, you have to have a vote of the majority of your shareholders before you can make that contribution? Well, but that's the same principle. The idea that before a corporation can run an ad saying, so-and-so is running for office, wants to shut down the plant and we'll all lose our jobs and our livelihoods, don't let her do it. Before they can run that ad, they have to get approval of the shareholders. Well, I guess, in my mind, that places corporate democracy over free speech. So those are the 5 arguments, including the imposition one. As I said, the court rejected those arguments. And here is a quote from what the court said. The court said, speech is an essential mechanism of democracy, for it is the means to hold officials accountable to the people. In a republic where the people are sovereign, the ability of the citizenry to make informed choices among candidates for office is essential. The right of citizens to inquire, to hear, to speak, and to use information to reach consensus is a precondition to enlightened self-government and a necessary means to protect it. I don't think anybody, the dissenters, anybody in this room, nobody disagrees with that, so that's okay. And then the other principle is, premised on mistrust of government power, the First Amendment stands against attempts to disfavor certain subjects or viewpoints. Prohibited, too, are restrictions distinguishing among different speakers, allowing speech by some but not others. As instruments to censor, these categories are interrelated. Speech restrictions based on the identity of the speaker are all too often simply a means to control content. And so what the court was concerned with, it's bad enough to restrict the ability of some groups or individuals to speak, but it's worse to do so when the suspicion is you're doing it because you don't want to hear what they have to say, or you think that most of them or most of those groups are going to say things of a certain persuasion, and you don't particularly want to hear that. So those were some of the core First Amendment principles that the court imposed. The court took a view that I've characterized as a unified and universal and indivisible view of political speech in this area. No second-class speech under the First Amendment. No second-class speakers under the First Amendment. Anybody, any entity, any group that wants to put the message out there, the government can't restrict them from doing so because of the kind of person or group they are. That's a fundamental principle. That's a principle which I think the court unfortunately forgot in the Austin case. That's a principle that I'm pleased personally and that the court reinstated and returned to in the Citizens United case. And I think ultimately that's a principle that's really better for democracy, because I think it's better for free speech to disable the ability of government to say who can speak and who can't and how much can be said. I think it's ultimately better for free speech to disable the ability of government to do that. And therefore, I think if it's better for free speech, it's better for democracy. Now, those are not the views, my views and the views of the majority, not just the views of 5 conservatives and a weird libertarian. I want to give you another passage from a Supreme Court opinion. Under our Constitution, it is we, the people, who are sovereign. The people have the final say. The legislators are their spokesmen. The people determine through their votes the destiny of the nation. It is therefore important, vitally important, that all channels of communication be open to them during every election, that no point of view be restrained or barred, and that the people have access to the views of every group in the community. Some may think that one group or another should not express its views in an election because it is too powerful, because it advocates unpopular ideas, or because it has a record of lawless action. But these are not justifications for withholding First Amendment rights from any group, labor or corporate. First Amendment rights are part of the heritage of all persons and groups in this country. They are not to be dispensed or withheld merely because we or the Congress thinks the person or group is worthy or unworthy. These words came in a case involving the Taft-Hartley Act. I assume that's not really popular in this zip code. The Taft-Hartley Act, which restricted both unions and corporations from making expenditures about politics. And the opinion was written, it was a dissenting opinion, was written by Justices Black, Douglas, and Warren. And for those of you of my vintage, probably the three most liberal justices who ever served on the Supreme Court. Now, if they could write an opinion basically saying that it's wrong for free speech and it's wrong for democracy to restrict the ability of individuals and groups, corporate and labor, to speak out about politics, well, then I'm comfortable in my libertarianism and hanging out with the five justices on the Supreme Court. A couple of final points, and then I'll be happy to yield the balance of my time, as they say. It's hard to tell by the press about the case, but actually a part of the statute was upheld in Citizens United. It was the part of the statute that required that anybody who runs an ad on broadcast mentioning Hillary Clinton or Obama, President Obama, whoever it may be, has to disclose on the ad who they are and has to file, I think, within a day or so, reports of where the money came from and all that stuff. A pretty significant disclosure of the source of the funding of these broadcast ads. The court upheld that as well, even though it was challenged. I personally think the court went overboard, but the court upheld that as well, as striking down the other parts. So the court's sort of bottom line was, let's let the speech go out there, but let's let it be effectively and fully disclosed so we can know the major sources of where it's coming from, and that's the best way to do it. We'll have more speech, not, as Justice Brandeis once said, enforced silence. We'll have more speech, and we'll have enough ability about where it comes from. Again, I have a caveat with that latter part, but the court didn't. And the court, with the exception of Justice Thomas, who's kind of a privacy, I don't say freak, but a privacy strong advocate, political privacy, everybody else, liberals and conservatives, all said, ah, yes, we love disclosure, and they upheld that part of it. So the coherence of the majority's position is, let the speech happen, let people know where it's coming from, let people decide. If it's good speech, bad speech, because of its source, let people decide if the officials who are praised or condemned or supported or opposed in that speech are then going to be too friendly or willing to cater to the interests of the people that engage in that speech. That's really the better way for First Amendment and the better way for democracy. I did want to make a couple of concluding thoughts. What's happened since the decision, of course, is well known, and Professor Beal alluded to it. Three things. Of course, the president's reaction, attacking the court the afternoon of the decision, and then, I've never seen it in my lifetime, I don't know if anybody here has, attacking them. They were sitting about as close to him as you folks are to me, and attacking them and mistakenly. Even the New York Times said he made a mistake in what he said about the court decision, sort of attacking them, and then getting the senators to jump up and applaud the attack on the court. And I thought to myself, if you flip the politics, you made it Bush doing that to a bunch of liberal justices who had just struck down a Guantanamo ruling, and a bunch of Republicans going like that in the face of the justices, we'd still be hearing about the threat to the independence of the judiciary. And somehow, everybody got a pass on that. Well, part of the reason is the press doesn't like this opinion, except for the Wall Street Journal. The mainstream press thinks it's a terrible decision. I mean, the New York Times has written 3 editorials about what a terrible decision it is. Well, maybe they're right. I don't know. I don't think they are. Maybe they don't want the competition. Maybe they don't want other people with money and corporate treasuries and all that to go out and say things about politicians. Maybe they want to kind of corner the market on opinion. That you hear it from the New York Times and that's it. You don't get to hear it from the widget company because they didn't go to journalism school. What the hell do they know? Maybe they don't want the competition. Or maybe they think that the press has greater rights under the First Amendment than anybody else. Well, I know they do. In fact, as Professor Beale said, my first book was The Rights of Reporters. I'm a fellow traveler of the journalistic community. My wife's a journalist. I love the press. And I used to argue the press had greater rights than anybody else because they represented us and they could get into places we couldn't and stuff like that. But the court has rejected that. The court has said the press has no greater First Amendment rights than anybody else. And so if you take that, then the press's view that it does have better rights, bigger rights, is kind of questionable. The politicians, well, I'm not going to talk much about the Disclose Act, except to say it's like so many other things. Half of it is, I think, flatly unconstitutional. The part of it that's arguable is excessive. But the main purpose of it, as Senator Schumer, my senator, said, is to blunt corporate speech. To blunt corporate speech. Or another way, in my mind, to shut up corporate speech. Again, you flip it. You get a conservative Republican president say the purpose of this bill is to blunt labor speech, to shut up labor speech. You say, you can't do that in America. Again, we got to pass on that. In any event, we'll see what happens with the Disclose Act. As I said, some of it is arguably valid. Some of it, I think, is flatly unconstitutional. I will conclude now. The ultimate essence of the court's ruling is that under the First Amendment, there are no privileged speakers and no pariah speakers. The First Amendment protects all those individuals and groups that would exercise their right to speak and communicate by disabling government from abridging the freedom of speech. That is the true form of leveling the playing field, putting all people and groups on the same plane and footing where freedom of speech is concerned. As I said, most of the press doesn't like the decision because I don't think they want the competition. Most of the politicians don't like the decision because they don't want the criticism and the pushback. But I think the competition and the criticism will inevitably work to the benefit of the public and the political process and ultimately to the strength of our democracy. Thank you very much.
Thank you, Joel, for a provocative speech. I'm sure we'll have some interesting questions, answers, and discussions as the evening ensues. Without further ado, let's move now to Juliet Thorpe Okodiebo and some of the practical perspectives on corporate election expenditures, independent, purportedly, election expenditures. Juliet Okodiebo is Senior Vice President of Public Affairs for MGM Grand Detroit. She serves on the Executive Committee of the Center. She is on the MGM Grand Detroit Diversity Council and the Board of Directors for MGM Grand Detroit. And she's on numerous boards here in the community, including the Detroit Economic Growth Corporation and the Michigan Roundtable for Diversity. She has responsibility for local, state, and federal government affairs, and that's a fairly broad responsibility. That means identifying, monitoring, thinking about strategies, developing policy recommendations to address proposals in the legislature, implementing lobbying strategies, all of the kinds of things that also impinge on whether corporations will, in fact, engage in the election process more directly or not. She's involved in community outreach and has maintained relationships with a number of community organizations and diversity initiatives. And furthermore, hooray for her, she's a native Detroiter who has a wealth of community experience here, including 20 years in Detroit city government. We welcome her tonight to the symposium and her perspectives on the role of Citizens United in corporate involvement in the future.
Thank you very much. I guess I'm representing the big bad multi-global evil empire. This is, I've worked in city government, as Professor said, for about 20 years. So I've had a career that's included experiences in different sectors of the economy, from city government, which is really a corporation in and of itself, a huge nonprofit like the Detroit Medical Center, a smaller nonprofit like New Detroit Incorporated, and banking, Comerica Incorporated, and now MGM Resorts International. We have 15 properties across the country, mostly located in Mississippi, Nevada, and Michigan, and in Macau, and we have interests in other in management responsibilities for other gaming companies around the world. And I guess the major point that I want to make in terms of what this means for how we do business, and I think the way that most corporations think about political expenditures, and that is that they are pretty much afraid of what the backlash may be. My experience has been in my corporate work, in those places that I cited that I've worked, is that there's a wariness on the part of corporations to get too deeply embedded in politics of any stripe. And basically, what corporations want to be able to do is to be left alone so that they can make money. Now, that's the long and short of it. And when we have to deal with the political spectrum and politicians and the like, it's usually very targeted to issues that affect the business and our ability to do business. And I can give you some examples on that. Here in Michigan, we have some of the most restrictive gaming laws in the country and probably in the world. When casinos were started here in 1996, the legislature decided to not sully the political landscape with gaming money, that it would be best to restrict the Detroit casinos from participating in any political campaigns except for at the federal level. So that means that we cannot support any local political campaigns or politicians anywhere except for at the congressional level. That's, you know, your senators and Congress people. And that's a two-edged sword there. The bad news is that without being able to spend money in the local political milieu, then you are kind of out of sight and out of mind when political people, or politicians, are making decisions. That's the bad news. But they are making decisions about your business. So how do you then begin to get your point across in the press with the kind of, with gaming? People hate it, or they love it, or they tolerate it. But it's a lightning rod. It's not an embraceable kind of an industry, especially in Michigan. It's not Nevada here. So we don't have a natural ally in the media. So that's a big impediment to us, and I can tell you one of the big instances of how it costs us millions of dollars here, being left out of the political process at the local and state levels. We can, however, though, be engaged in ballot or policy questions. We can spend money on that. We can advertise, we can support groups when it comes to ballot proposals or policy issues that affect our company. And we had to do that back in 2004. I don't know if many of you are aware that Michigan has 24 casinos. That's quite a lot in a state this size. Only 3 are non-Indian casinos. There are 24. And back in 2004, with the state facing shrinking revenues, it was thought that the Michigan Lottery Commission would get into the pull tab business, which is pretty much putting slot machines in corner stores or anywhere else they wanted to. Racetracks would get involved in gaming with slot machines. You know, there was going to be a proliferation of gaming. Now, we had just decided to put $1 billion in the ground to build our new facility. So what does the corporation do? That is a very, very daunting task to try to think about how do you move the broad public opinion and the opinion of politicians who are making decisions about these ballot proposals to to protect your interests. And that's pretty much what corporations want to do, protect their interests. So we embarked then, not being able to support any particular politician to further our points of view, we had to go to a statewide ballot initiative. It cost us probably close to $20 million to do that. And I've often said that it might have been about a $200,000 problem, but it was a $20 million problem. We had to present, through our ability to present our point of view on this policy issue, advertisements, develop a whole campaign to inform the public and educate the public, not to sway public opinion necessarily by spending and flooding the market with $20 million, but it took absolutely that much money to educate, to buy TV time. There were no surrogate people who could speak on our behalf. There were no politicians who could stand up and speak for us. So we had to go directly to the voters. And we developed a campaign that posed a simple question. Do you want, how many casinos do you think are enough in Michigan? How many are enough? Who do you think should decide whether or not casinos are around the corner from you? And the voters thought about that, and with the information that we provided, because there would have been up to 15 new casinos immediately, would have taken the total up to about 40 in Michigan. They said, okay, if a local municipality decides that they want to have a casino in their town or jurisdiction, that's fine, but it has to also be approved across the state. Everyone across the state has to vote on it, and it has to have a supermajority. So that was proposal one, and that was passed in 2004. Now that didn't stop other threats to come along that would have, like just recently, there was a ballot proposal that could have gotten on the November ballot, and we were watching that carefully to essentially gut what happened with proposal one back in 2004. But I say that to say that we have a pretty unique perspective here, because as in Nevada, where gaming is a major industry, in Michigan it is not. So one of the things that we do, and I think this is pretty much how most corporations think about the political landscape. You never have enough money, I think, to buy a particular point of view or to buy an election or that sort of thing. There have been a lot of very rich people and backed by big corporations who have lost very handily when they've attempted to do that. I think voters are turned off. The major thing that corporations want to do, besides be able to show a profit, to operate on a level playing field, corporations have to be very much involved in protecting the brand. We just got the first test. I don't know if it's the first test, but you may be aware of what happened with the Target stores in Minnesota just recently, and this is one of the first forays into being able to do exercise free speech and endorse candidates with corporate money. That happened in Minnesota, when Target donated $150,000 to a group called Minnesota Forward in support of a governor, would-be Governor Emmer. And it was discovered that Emmer was very much against same-sex marriage and very much right to life and, that sort of conservative bent that caught the ire of the GLBT community. And that community immediately started a ground war against Target. They called for a boycott, there were blogs, they're Twittering, and the YouTube, the whole thing. We're so disappointed. How could you do this? Now, Target's excuse was, well, we didn't know that. We just thought, he was a good candidate because he stood for, good solid business principles. Wrong answer. The people who shop at Target are of all stripe. And when they get accustomed to looking at a brand and they have brand loyalty, they feel betrayed. if for some reason that corporation seems to take their business for granted or thinks that they are not as important as some other business, initiative that's going on. And Target has been stumbling over this issue ever since it happened a couple of months ago. And I think it's indicative of the wariness I talked about in terms of corporations. If you don't protect your brand, then you're going to spend more time and more money trying to reinitiate people to your product or service after they've been turned off. And just in closing with that, I'll just mention, as big as our company is, and even in Nevada, we spend more time connecting with our employees to get them educated and to have them as ambassadors about our business goals and objectives than we do in currying favor from individual politicians. We have an organization in Nevada called REV, where we educate, register, and encourage our employees to vote. I started a policy action team here so that we can visit elected officials. We have the right to do that. We can't support their campaigns, but we can pay them a visit and share our point of view. And we find that those things are much more effective than the other way of doing it, because we worry about transparency and we want to hold corporations accountable. But I don't think that's really an issue anymore, because with all the technology, everything is transparent. Nothing can be done in the dark that won't come to light in the next 5 seconds after it's said or printed or the money's been handed from one person to the other. So with that, I think that pretty much summarizes what I think my perspective is on the corporate side of this case and its impact. I look forward to having more free speech. I hope that this will lead to our company in Detroit being able to get more involved in all facets of politics, not just to be limited to ballot proposals. And I'll look forward to questions.
Thank you so much. Our next speaker and our final panelist is Steve Winters, who, as many of you know, is the Walter S. Gibbs Professor of Constitutional Law here at the law school. He's taught at Brooklyn Law, University of Miami, American, Cardozo, and Yale. Clerked on the Second Circuit, worked at the ACLU, prepared many civil rights cases, and worked on more than a dozen Supreme Court cases. So he certainly comes with the credentials for talking about these issues in the constitutional law, and is a prolific author with numerous articles and various books, including one he's working on now on the question of consumerism and democracy, which touches on some of the issues that come up in Citizens United. Without more, I turn it over to Steve.
Thank you, Linda. I know it's late, but the advantage I have of going last, that you may be tired, but I suspect you might want to hear what the other side sounds like. So I hope I can hold your attention for about the next 12 to 14 minutes. I've chopped it as much as I can. Let's be honest. Our democracy is in serious trouble. From swift boaters to birthers, from WMDs to death panels, from anchor babies to fictitious beheadings in the Arizona desert, from Glenn Beck to Newt Gingrich, our public discourse is a toxic mix of rumor, myth, half-truth, deliberate distortion, outright fabrication, guilt by loose association, and other whopping non sequiturs. I'm skeptical that any amount of campaign finance reform can repair this problem. But I am confident that to take a crude First Amendment crowbar to the only levee that keeps the surge of corporate funding from the maelstrom of modern mass media culture is a recipe for disaster. To think otherwise, you would have to have your head firmly ensconced in a First Amendment bubble circa 1973. I'm about the same age as him. He's slightly older. When lunch counter sit-ins, civil rights marches, and anti-war demonstrations were recent, still vivid lessons in the value of free speech, when all reporters aspired to be Woodward and Bernstein, when people actually watched the CBS Evening News, and Walter Cronkite was, quote, the most trusted man in America. And when an old school mistrust of governmental power was made flesh in a paranoid president with an enemies list and a secret black ops unit operating out of the White House. I came of age in that time too, and as I've written previously, the fundamental First Amendment question of that day was how far to extend the boundaries of free expression. Radicals like myself thought there should be no boundaries at all. But we live in a different time. A time of viral emails, Fox News, Facebook and Twitter, and an ever-escalating flow of money into the political system. As the New York Times reported just this Tuesday, political spending in the last 5 weeks, just the last 5 weeks, just on television ads and just for congressional races, no state races at all, totaled $68.3 million. Right? That's in 5 weeks. Nearly 17 million of that was from private groups, with the Republican-leaning groups outspending Democratic groups by a margin of 5-1. The dean told me just at the cocktail party here at a report on NPR this evening that normally in midterm elections the spending goes down. First time ever, it's gone up by 10%, and it's largely being attributed to corporate funds. But we don't actually know that because the New York Times reported on Tuesday, most of the money is not being channeled either directly by corporate speech or through PACs or 527s, but through 501Cs, through not-for-profit corporations, which do not have to disclose their contributions. So we don't even know who's spending, there's no transparency. Joel makes a spirited, I'm going to call him Joel because I've known him for a long time. So Joel makes a spirited defense of the decision Citizens Union, but his argument, like the majority's opinion that it reviews, is long on free speech rhetoric. First Amendment rights, he says, should be unified, universal, and indivisible, but short on empirical data, social context, and constitutional vision. One cannot assess the likely impact of Citizens Union on our democracy without an empirical understanding of the dynamics of modern mass media culture and its impact on contemporary politics. Beyond that, one would need, first, a theory of free speech, second, a theory of truth, or at least of how people come to hold the beliefs that they do, third, a theory of democracy, and fourth, a decent socio-legal understanding of corporate behavior. The First Amendment, Joel says, has always been based on the idea that the more speech we have, the better off we are as individuals and as a people. Well, not quite. As a historical matter and as a conceptual matter, there have been not one but several First Amendments based on different normative underpinnings and different conceptions of truth. For the framers, who held a strong view of truth, it was perfectly reasonable to punish false speech after the fact. Thus, the chief innovation of the founding period was the notion that truth should operate as a defense to seditious libel, a reform carried forward in Section 3 of the Sedition Act. Even Jefferson, an opponent of the Sedition Act, had no qualms about referring what he considered offensive falsehoods for prosecution by state authorities, Justice Holmes, writing in the early part of the 20th century, in contrast, held a Darwinian conception of truth as that which emerges from the contest of views. Most of us are familiar with his claim that the ultimate good desired is better to be reached by the free trade in ideas, the so-called marketplace of ideas metaphor. But his was not the Miltonian faith that no one, quote, ever knew truth be put to the worse in a free and open encounter. His, rather, was a cynical understanding, quote, that truth was the majority vote of that nation that could lick all others. Holmes viewed free speech as a no-holds-barred competition between vigorously contested views that must ultimately yield to, quote, the dominant forces of the community. In mid-century, Justice Brennan's more liberal version championed the idea that debate on public issues should be uninhibited, robust, and wide open, and should be characterized by the widest possible dissemination of information from diverse and antagonistic sources. But we don't live in 1644, when Milton did, in 1789, in 1919, or even in 1964. We live in a media age in which the insight that truth is socially constructed has become a practical axiom. There are now a host of social and political institutions that have developed ever more sophisticated ways of designing, marketing, and disseminating images and other symbolic forms through ever faster and ever more pervasive technologies of communication. Every day in this country, truth is put to the worse. A huge number of Americans, somewhere between 38% and 52% of all Republicans, think that President Obama is a secret Muslim or that he is sympathetic to the jihadi project of imposing Sharia law worldwide. Newsweek, I'm not making this up. Nearly a fifth of all Republicans believe that Obama was not born in the United States, even though his birth certificate is posted on the internet. You can look it up yourself. Joel observes that, quote, no one seriously disputes that the primary purpose of the First Amendment's guarantees of freedom of speech is to enhance democracy by ensuring an informed electorate capable of governing its own affairs. But where is that informed electorate? What has happened to its capacity to consider factual claims and accept or reject them on the merits? What has happened to our naive faith in the marketplace of ideas? In his book, The First Amendment, Democracy and Romance, Steve Schifrin warns against monolithic theories of free speech. There are, he points out, a host of First Amendment values that include tolerance, liberty, self-governance, the dignity, equality, and autonomy of all individuals, the value of self-expression and self-realization, and Emersonian romanticism. He's big on that, hence romance in the title. Each of these normative conceptions asks us to think about free speech in a different way. Each leads to very different conclusions about the place of corporate speech under the First Amendment. I don't have time to draw them all out here, but the two most obvious implications are, first, that speech is a quality of flesh and blood humans whose liberty, dignity, and self-realization the First Amendment was meant to protect, and second, that free speech is one of the defining aspects of citizenship, and thus a characteristic not of commercial enterprises, but of self-governing legal subjects. I will say more about these in a moment. Suffice it to say that for-profit corporations do not fare well under either of these understandings. In a parallel conceptual vein, Ed Baker's book, Media, Markets, and Democracy, reminds us that there is more than one theory of democracy, and that different theories of democracy provide different answers to the questions of what type of free speech we need and why. Elite or Schumpeterian democratic theory sees democracy as a system in which policy elites compete for the approval of the masses who, truth be told, couldn't be bothered by the complexity, difficulty, and time-consuming nature of actual self-governance. On this view, the role of a free speech regime is to provide information and transparency, that is, to serve a checking function on accrued, corrupt, or ineffective government power. Independence is the key characteristic of this model of free speech. Liberal or pluralist democratic theorists view democracy as a competition between individuals and groups over divergent interests, values, and conceptions of the good. The results of these conflicts are aggregated through voting and mediated by bargaining and compromise. On this view, the role of the First Amendment is to guarantee that individuals and the interest groups to which they belong receive adequate information about when their interests are at stake and about how and when to mobilize to defend them. The key characteristic of this model, characteristics, plural, of this model, are the independence and diversity of informational sources. Contemporary civic Republicans like myself understand democratic self-governance not on the model of an individual right, like the right to liberty or the right to own property, but as an unavoidably communal enterprise in which we share with others the authority and the responsibility to decide the conditions of social life. This requires participation, mutual recognition and respect, conditions of solidarity in dealing with the problems of our collective existence, what in classical Republican theory is expressed in terms of the res publica, or the common good. On this view, the role of a free speech regime is to promote the conditions necessary for the deliberative discourse that constitutes collective self-governance. Independence and diversity, though now in the form of inclusive participation, remain desiderata. But on this model, fragmentation, excessive partisanship, and overtly strategic communication are absolutely deadly to democracy. The key characteristics of this model are a reflective, inclusive public discourse that respects differences and promotes responsibility and solidarity. These three models of democracy are hardly exhaustive, and I've passed over several others, including, I think, particularly interesting Chantal Mouffe and Ernesto Laclau's Born Postmodern, Agonistic Pluralism, and Various Forms of Subaltern Theory. The point is that each of these different conceptions of free speech, each of these different conceptions, each of these yield different conceptions of the free speech that a democratic polity would require. The overall point should be clear. One cannot say that a particular ruling, such as Citizens United, or a particular political practice is a win for democracy without both saying what you mean by democracy and then explaining why that particular democratic vision is normatively superior. Even then, one would have to show that one's normative claim is either accurately descriptive of, or at least empirically plausible under modern conditions. Now, maybe I'm making too much of this silence. Surely we can infer that it is a liberal pluralist view that Joel is defending here tonight. But there is an equivocation that runs throughout his paper. It didn't surface quite as obviously in the oral version of the talk. He didn't see these remarks, so and this equivocation undermines this otherwise simple solution. Free speech rights, he declares, quote, should be available to all those individuals and groups which seek to exercise them. Joel denounces, as he did tonight, the idea of a caste system of free expression with second-class or pariah speakers. At the same time, however, he asserts that it is, quote, the importance of the speech, not the identity of the speaker, that determines protection. Quote, we protect the speaker to protect the speech. Now, I raise this ambiguity for two reasons. First, the argument for the primacy of the speech over the speaker is a traditional hallmark of a civic Republican approach. As Alexander Michael John famously remarked, quote, the First Amendment does not mean that every citizen shall speak in the public debate, but that everything worth saying shall be said. It matters here because what is at issue in Citizens United in cases like it, and in general in the campaign finance debate, is not the substance of the speech, but its provenance. It's not just that in the case of restrictions on campaign expenditures, there are other people out there saying the same things. It is rather that the same speaker can say exactly the same thing as long as he, she, or it does so at an earlier time or using a different legal form. The court in Citizens United observes that, quote, speech restrictions based on the identity of the speaker are all too often simply a means to control content, true enough, but that is not at all what was happening in that case or in the issue that we're discussing tonight. Second, and this goes to the heart of the argument, the systematic conflation of speaker and speech in Joel's argument works as a rhetorical device that allows Joel to have his cake and eat it too. He uses it on one hand to defend against the argument that only people should have free speech rights. It's the speech, not the speaker, that matters. On the other hand, he misappropriates the moral attributes of personhood when he says that corporations cannot be treated as second-class citizens, pariah speakers, or political untouchables. These kinds of dignitary harms are unique to persons, not abstract legal entities. To get a proper sense of the distortion, consider your reaction if I said that Ralph Nader or Michael Moore is a racist against corporations. If you didn't think me odd, you would assume that I was speaking metaphorically. And that's the point. Money is not speech, though it can be a useful instrument in getting your speech heard. A corporation is not a person, though it is an effective vehicle for accomplishing various human purposes. Joel at one point acknowledges this, but then he asserts, as he did in his oral remarks, that corporations are just an amalgamation of people, quote, that they're made up of, run by, and embody the interests and concerns of real people. Therefore, they should get the same rights. But this is not just a fudge, this is a monumental fudge. First, he's once again shifting his ground from the argument that it is the speech and not the speaker. He is explicitly invoking the interests and concerns of flesh and blood humans, people who work at the corporation, to justify the free speech rights that he claims shouldn't be restricted to real people. Right? So we let the corporations speak because people have to be allowed to speak. Right? It's a nice move. Second, he's eluding entirely, and he drew the difference between corporations and media corporations, but I think it's important that the heart of the objection to Citizens Union is not the not-for-profit, it's not the 501c corporations, it's the extension of the extensive dicta, the language that Linda quoted at the top, that this applies to all corporations, what I'm going to refer to as commercial corporations, the for-profit ones. So think about this. What are the interests and concerns of the real people who make up a corporation? When we're talking about an advocacy-oriented not-for-profit like the ACLU or Citizens United, it is precisely the protected speech interests of flesh and blood humans at issue. But when we're talking about a commercial corporation like BP or Halliburton, the interests and concerns of the people who staff the corporation and speak for it are entirely irrelevant. The corporation has only one interest, and it is mandated both by the market and mandated by corporate law. The only interest they're allowed to have is to maximize the wealth of the shareholders. To put it differently, the commercial corporation is not at all like a real person. It is not interested in self-realization. It finds no inherent value in self-expression. It couldn't care less about Emersonian romance. It has no loyalty to its employees or its community that isn't trumped by the bottom line. If it is more cost-effective, it will outsource its jobs and relocate its factories abroad because its sole concern is profit. The real people whose dignity and self-governance we care about are complex moral beings. The commercial corporation is a single-purpose entity that, in a word, is not an object of citizenship. So I'm going to conclude with this, what will seem like an odd thought. In Chicago, there's a downtown Chicago, right on Wacker Drive. I walked by it this summer. There's a statue of George Washington, and he's flanked by Robert Morris and Chaim Solomon. Now, my bet of you is that most of you here have never heard of Chaim Solomon and have no idea who he is. Probably heard of Robert Morris because he signed the Constitution and he signed the Declaration of Independence, and he was the superintendent of the Treasury during the Revolution. Chaim Morris was a Polish Jew. Sorry, Chaim Solomon was a Polish Jew who emigrated to New York in 1775. He was a financial broker, a member of the Sons of Liberty. He was arrested excuse me, and tortured by the British as a spy, and he was able to negotiate a pardon, at which point he moved to Philadelphia and became the principal financier of the American Revolution. Estimates put his loans to the United States during the Revolution excuse me, and the early days of the government at between $600,000 and $800,000 in 18th century money. Think about that. When Washington needed $20,000 to march the troops to Yorktown and the treasury was empty, he sent a 4-word dispatch, quote, "Send for Chaim Solomon." Legend has it that Solomon lent so much money to the fledgling government that he died broke. The reality is actually more complex, though it is true that his descendants twice unsuccessfully petitioned Congress for repayment of some of the loans. Why do I mention him? Does anyone in their wildest imagination think that Halliburton would similarly underwrite the war in Iraq? Given our whopping deficits, would it rebate to the United States some of the billions in profits it earned during the war? A First Amendment that equates corporations like Halliburton with citizens like Chaim Solomon is not a unified, universal, and indivisible. It is dangerously oversimplified.
Thanks much, Steve. We've obviously gone a little bit longer with each of our presentations than we'd expected to, but we wanted to have some time for audience participation, so we will do that for those of you who are willing to stay around for a few more minutes. I think we've heard quite a few different perspectives on the question of corporate citizenship or not, and there are probably many questions that occur to you. I would like to throw one out, which is, I think, a very simple question, probably for Joel. And it is the question about the case law and the question of whether we have really, throughout the history of our country, thought of corporations as the kind of entity one would expect to be participating in the electoral process. And I note that the earlier cases that seemed to draw back from such a broad conclusion reflected, as you said, Joel, considerable deference to Congress. And if you think about it, this court in Citizens United seems to be making a conclusion as a matter of law about issues that many of us lawyers would think are essentially questions of fact, as Steve said, without the empirical support one would expect, such as Do independent, purportedly independent expenditures of corporations give rise to corruption or the appearance of corruption? Do corporations' involvement to a large extent in electoral campaigns, do they present a real potential for distortion of the decision-making in the campaigns? And I'm just curious, Joel, how you answer the fact that the court has in the past deferred to Congress on those kinds of factual decisions, but here in Citizens United did not do so.
Well, I guess not to be flip, but the short answer is they were wrong in the past. These are First Amendment matters, and while we might defer to Congress's fact-finding on other kinds of questions, I'm not sure why we want to defer to them on fact-finding. I'm not sure we defer to them on anything these days, given some of the things they produce without apparently having read them. So I think deference and First Amendment usually don't go together. And the skepticism that the court showed about Congress and its fact-finding and its motives in Buckley and showed again in Citizens United, to my mind, is more in keeping with the kind of review that should go forward when First Amendment rights are at stake than the normal deference Congress might get when it's investigating what's the safest way to make a widget. Because I do think you can't discount the congressional self-interest. Now, I'm not saying that carries my day completely, but they are writing the rules that determine whether they will be reelected. And so I think for that reason alone, it's almost like an inherent conflict of interest. You're entitled to give greater scrutiny and skepticism to their work product than you might in sort of the other run of legislation.
Steve?
Yeah, the last point that Joel makes is clearly valid. The two things I would note in this partial agreement with Joel, and that is they don't give deference to anything anymore. That changed around the mid-'90s. It changed in Lopez, it changed in Fuentes, and in Morrison, which was the Violence Against Women Act case, and actually a host of cases. So that's been a sea shift in constitutional law. The other point that I would make, which is not in disagreement with Joel, but it's just separate, is the fact that they have no empirical sense of what's going on in the world, that's also always been true. That's not unique to Citizens United, nor is that changed. That was something that Brandeis tried to introduce to the court in the early part of the century, but failed. Mm-hmm. He used to give Holmes books to read, and Holmes would say, "I don't read them; they're too boring."
Yeah.
Just on the empirical point, because I think it is an important issue. Steve describes a really. And by the way, I'm reminded the years that Steve and I were colleagues at Brooklyn. Whenever Steve talked, it was like being in the presence of a surgeon. I mean, it's just this precision with which he cuts up arguments, and it's sort of like the operation was a success, but the person who's criticizing died. So anyhow, so I'd forgotten how bracing that could be, and I've taken very extensive notes, and I'm going to read Steve's paper and try to respond in mine. So, but on the question of how things work in the real world. We have a couple of laboratory experiments. Oh, two things. First, I don't think the grim world that Steve describes about toxic communication and control of communication, all that stuff, you can't lay that at the doorstep of Citizens United. It's only 6 months old. No, and that's been going on for generations. Right. And our mutual friend and late departed Ed Baker wrote about that, and McChesney writes about that. A lot of people write about sort of media concentration and its sensorial effect on our communication. That you can't lay that at the doorstep of Citizens United. But in terms of the effect of corporate speech on politicians and politics, we have two laboratory experiments. Number one, as was pointed out to the court, and the court referenced this, half the states have permitted corporations and unions to make independent expenditures in campaigns. Precisely what Citizens United says now the First Amendment requires. And there was no evidence presented by the supporters of the law to show that those states were cesspools of corruption, and that the states which didn't allow independent expenditures were gold star good government states. So if you're looking for laboratory experiments, look at that. Congress didn't look at that. They just passed Taft-Hartley, and then they expanded it in McCain-Feingold. shut them down. But where those states that hadn't shut them down, 25 or 26 states, some of them are the best governed states in the country, according to various opinion polls and surveys, stuff like that. So that's laboratory experiment number 1. Laboratory experiment number 2 happened in 2008. Because under the campaign finance law in 2008, every corporation in America, including all the Exxons with its billions of profits sitting around, et cetera, could have run ads in any medium of communication every day, 24/7, telling us that Barack Obama was a terrible person and saying all the worst things in the world they want about him. And you would have thought if there had ever been a candidate that corporate America would have unloaded on, a former community organizer who had never shown much interest in the business side of the ledger, who railed against corporate special interests, all that stuff, they would have unloaded on him. Not a word. I have not been able to have anybody show me a penny of Exxon money that was spent in the 2008 elections to try to defeat President Obama. And so there's the other experiment. Maybe it's part of what was referred to earlier by Dr. Okoti Igbo, namely there's a real self-censorship about corporations getting involved in all that stuff. I mean, after all, their clients and their customers are Republicans and Democrats and independents and all across the spectrum. And so they're very hesitant about that, whatever the reason is. As I said, corporations could have done anything except expressly advocate the election or defeat of a candidate. They could have done anything else short of that in any medium, and you would have thought if they were going to abuse this power and try to swamp the elections, that would have been the election to do it.
Actually, why would you have thought that? In fact, the corporate interests gave much more heavily to Barack Obama than it did to John McCain by a factor of either 2-1 or 3-1. Right? With corporations, first of all, he was not seen as a left-wing candidate
Right.
for corporations. He was right, slightly right of Hillary,
Okay.
he was more moderate.
Okay.
And secondly, he was quite pro-corporatist, and they got that. The second thing is, so that it's not a test case at all.
Okay.
The second thing
How about
is,
the 26 states? Those
the
are
26 states is a good point, although not a laboratory, right? That's the problem, right? But the other thing about is that what corporations do and what they did in 2008 is they give to both sides. They always do that, and they did that in 2008. Based on who they think is going to win, they give more to the side to be on the winning boat, but they hedge their bets, right? Just in case McCain pulled it out.
Right.
They didn't want to have a check from Exxon not be going across McCain's
And as far
desk.
as the laboratory with the states go, we haven't really had an empirical study, have we?
Well, and it's very
carries
hard
out-
to do a
and it would
controlled
be hard
empirical
to do.
study.
Right.
Well, the
That's
people
why
who-
it's not it's a laboratory of democracy in the Bernaysian sense,
Well,
but
people-
not in the social
people-
science
Well,
sense.
but people have looked at it and tried by
Right.
the measurements you can have of good government, clean government, stuff like that, to compare it with states that allow these.
But you can't
expenditures.
necessarily conclude that
On the other
corporations
hand,
haven't distorted
you do
it.
have Caperton versus Massey Coal, which was, I cut it to try and save time, right? But in 2004, Don Blankenship, who's the president of Massey Coal, right, spent $3 million to get Justice Benjamin elected to the West Virginia Supreme Court. While a case against Massey Coal worth $50 million was pending in the state court system. And Benjamin gets elected, and he decides he cast the deciding vote to overrule the $50 million award. And the Supreme Court vacates it on due process grounds, on the ground that this is an obvious appearance of impropriety, right? Just to give you a sense, the $3 million he spent, 2.5 were independently and not coordinated with the candidate. He printed things out of his own, right? So it's like, the problem is, the measure is show me the coordination. If it's independent, by definition, it's not influencing. But that's obviously not the case. The other thing to notice is that he spent $3 million, was 3 times what Benjamin spent on his entire campaign.
Let's get Juliette into this discussion here again, too, and then we'll open it to the audience. I guess one of the things that I found interesting in what Joel said was that this was really a simple case, that you can't limit speech, said in somewhat conclusory fashion, and that really this independent advocacy was important for citizens, this notion of citizen. And I guess my question for you, as a person who thinks about these issues a lot from the corporate perspective, is that doesn't all of this depend upon how we view the corporation? Do we view it as just a group of citizens bonding together in corporate form, or should we view it differently? Is the fact that it is a legal, artificial entity created by the state to pursue the profits for the shareholders, a critical factor in thinking about what the corporation's role ought to be.
Yeah, I think there's a lot of validity to your last point, but I think it is a conglomeration of people, but they come together for a purpose like most people do when they gather together for a particular goal, and as I said, to make money. You know, you can't keep the doors open, you can't employ people, you can't provide goods and services if you are not making money. I don't see that as a negative in terms of looking at a corporate goal or objective. And I do think that there is a point of view that is espoused by corporations that may or may not align with an individual. And you know, my politics, my political point of view personally may be quite different from what it may be when I look at candidates or issues from my corporate point of view, because I've got two different hats on. So when I go in the ballot box, I may have one perspective on a candidate. I think I tend to probably be liberal, but when it gets to the money part of things in my company, you know, I'm getting a little bit more conservative. I want to just put those simple labels on it, and I hate to do it that way. So, and I don't feel conflicted in terms of being able to express myself through my work and personally as well, and both done through the ballot box or done through my own personal support or writing checks or whatever it may be. But one other point, just a practical observation too, you know, much discussion is had around the corporate table about how easy it is for politicians to get in trouble all by themselves. And, you know, they really don't need a lot of help from us. I mean, there are many instances of corporations, you mentioned Halliburton, it's quite a few, you know, that have abused power. I would argue in many instances Halliburton may be a creation of government. So, you know, there are many instances where corporations have been lockstep in the political spectrum and done some things that are a disservice to the community and disservice to our form of government. But if we even look locally here, you know, how many corporations were mentioned in all of these years of scandal that we've been burdened with locally? You know, so, you know, corporations sullying the pristine moral political landscape.
It's not going to fly in Detroit.
It's hard to get there.
Well, I guess the question for me is, who determines what the will of the corporation
Right.
is? Because it's fairly clear that shareholders don't really have that kind of power through the corporate governance system, and that managers often end up being the voice of the corporation,
Sure.
not the owners. So that thinking of it as an association of the shareholder owners having just one more voice in the electoral raucous speech is, I think, quite a stretch given the way the corporation actually works.
On the
How
easy-
about questions
on
from...
the easy question, I just want to say one thing. I actually agree with Joel on that. I do think citizens union is an easy question, but I do think that means that the sense argument that there was a narrow ground is also right. So,
Right.
and I feel about Hillary the movie the same way I feel about the Hustler cartoon of Jerry Falwell having sex with his mother in an outhouse. It's not art, and it makes no contribution of substance to the public discourse, but it clearly needs to be protected under the First Amendment, because a lot of other stuff that does matter that is viewed by people as equally provocative. And I agree that advocacy corporation like Citizens Union or the ACLU ought to be treated differently. One of my complaints, criticisms of Joel's paper is precisely the lumping in.
Right.
Right. So I think the issue is with for profit, not for ideological corporations.
Well, I lumped it in, but I learned from Congress, because they lumped them
Right,
together.
right.
They treated all corporations the same. When the McCain-Feingold bill was up, there was something called the Snow-Jeffords Amendment. It would have carved out from the ban on corporate expenditures nonprofit corporations, ACLU, stuff like that, as long as they didn't use any corporate money for those expenditures and they disclosed anybody that contributed more than $1,000 to those ads.
It's only, see, I agree
And
with
media.
that. If
And-
only Congress could compromise, we might actually get a reasonable
And
law.
the late Senator Wellstone violently, not violently, but strongly resisted that amendment And he said, those nonprofits are putting out those ads too, those poison ads and all that stuff, and we got to get them all. And so I don't want to defer to that. And I agree with Steve. I would say this, I don't know if you can say anything off the record while the mic's on, but if Congress had just, if Snow Jeffords had passed, if Senator Wellstone had failed in his efforts to not carve out the nonprofits, I'm not sure what would have happened. I mean, it would have been such a harder case if it's just GM, because it was also AFL-CIO, so you have to carve out unions too. In a way, Austin, which is just business corporations, is a much tougher case for me to argue against than Citizens United.
And that's what most of the argument here has been about, is the for-profit corporation.
If Congress were a little more restrained, I could be a little bit more restrained.
Let's take a few questions from the audience so that we at least see what is rising to people's mind. Yes, sir. Please identify yourself. And
I will. My name is Joe Canfield. I'd like to thank the panel for a most interesting and provocative evening. I want to say Bob Sedler convinced me that Citizens United was a correct decision, but since then I've been having second thoughts.
It reflects well on you.
Oh, yeah, that's right.
And,
Not on me.
and my concern is this. I think that money can not only buy elections, I think it could buy America. And there's a very interesting book called Invisible Hands. I'm sure I forget the author, but with me, memory is a sometimes thing. And the thesis of the book is that after the New Deal was passed, several business leaders got together and said, we've got to do two things. We've got to turn back the New Deal, and we've got to destroy unions. And the conclusion is that they've done it. It wasn't a one-time event. It was over the course of time. It was money that did it. It was big business that did it. She documents her argument very well. So my concern is, and my question to the panel is that a legitimate concern? And are we really on the same spot that we were when the Constitution was passed, when people got up in a soapbox and talked, and there was a debate? Or is big money just controlling almost everything we hear because they're buying out everyone else? So, thank you.
I think that's the issue of distortion. Steve and Joy and Juliet, if you could just each speak
I was just
briefly.
going to say, Steve accused me of living in 1973. You're talking about people sort of on soapboxes in 1793. I mean, the world of communication has changed so much that I'm not sure that an individual can communicate effectively nowadays without linking himself or herself up with some group. And I think the other problem is, it's like so many other things, the devil's in the details. I may agree with you that corporations have set about to make things bad for the rest of us and good for themselves, but I'm not sure that a campaign finance law is going to, what effect is that going to have? I mean, the grim situation Steve described came before Citizens United, and I don't think could be laid at the feet of any limitation on campaign finance restrictions. So, I mean, your problem is really a much broader one than I think you can solve by adjusting First Amendment doctrine one way or the other. I mean, for example, the corporation that wants to persuade the public to feel differently about casinos or things like that. I mean, I don't know, would you say they shouldn't be able to have a campaign like that because they're a corporation and maybe they're encouraging gambling too much and the people that want to oppose gambling don't have the same amount of money to spend? I mean, it's really hard to figure out how you go from your critique to some kind of a solution in light of these statutes and First Amendment and things like that.
I just want to correct the record. I never claimed that the Citizens Union caused the problem of toxic politics in the United States. What I said was, given that we have this toxic politics, letting loose all that money into it is a recipe for disaster.
It's
right?
a drop in the bucket. Just a drop.
No, I don't think that's true. As far as I think my answer to you is yes. I agree with you. Kurt Vonnegut in the 1960s, the late Kurt Vonnegut, the author, wrote in the introduction of one of his books, he says there are two parties in America, the haves and the have-nots. The haves have both of the political parties, right? And that's been true for a really long time. And the Citizens Union is not going to change the drama. The fact that you know, the Exxons and other large corporations give both to the McCain and the Obama campaign, and in large amounts based on who they think is more likely to win, is, you know, confirms your point. On the other hand, you know, I guess the other thing I would say is, you know, Learned Hand used to say, and I'm going to paraphrase it badly, maybe Bob Sedler can correct me, right, that people who love liberty don't need the Constitution to save them, and the people who don't love liberty, no Constitution will save.
Do we have another question? Over there.
Hi, I'm Stephen Watsman. I'm a 1L here, and this question is for Professor Gora. First of all, thank you for coming out. Professor Winter sort of alluded to this, but I had kind of a problem with, you laid out those 5 points about the arguments against that sort of thing, and the first and the fifth one sort of conflicted for me, and I wanted to hear your sort of answer to this in terms of, if corporations have free speech because they're an amalgam of the people that comprise them, how is it that the people who comprise them don't necessarily have a voice in what the corporations do?
And I wasn't suggesting they don't. In fact, I guess the construct is that a corporation, a stock corporation, the ultimate owners of the corporation are the shareholders. Now, what I was saying was that the idea that because of that, you would pass a new law that said any corporation that wants to run an ad that mentions a politician can't do so unless a majority of its shareholders approves in advance, that the purpose of that new kind of law is an effort to stop the corporations from engaging in that speech, and that kind of a mechanism, so far as I know, has not been applied up to now against the other kinds of expenditures corporations make that may or may not be satisfying to their shareholders. I gave examples of charitable contributions to entities that some people think are not very good entities. And so that's the point I was trying to make. Not that that the shareholders are not important, indeed constituent parts of the corporation, but that I think a rule which would say a corporation can't speak through its managers on behalf of its shareholders unless the latter approve in advance by a majority or some strong number, that in effect is like a prior restraint, because that won't happen. And it's tantamount to saying corporations will not be allowed to engage in that kind of speech, because you can't mobilize enough shareholder approval in advance it's like a prior restraint.
But there is some inconsistency there, isn't there, in your worry about the mechanisms to get shareholder approval contrasted with the argument for corporate voice because it is an association of the people who own it. Whereas in fact, corporate decisions do not very much reflect shareholder ownership decisions at all, right? They barely reflect the board of directors, very minimally reflect the shareholders, and the main way shareholders vote in a corporation these days is by selling the stock, right? Not by actually having a voice just to somebody else.
I think all I'm saying is
so there's an inconsistency there.
Well, I'm not sure, it may be. All I'm saying is that I think that given both what you're saying and the ownership of so much stock through mutual funds and pension funds and things like that, that if you imposed a majority shareholder requirement for any kind of political speech by the corporation, it's tantamount to saying that they can't engage.
I think Juliet wanted to get in on this one too.
Yeah, I was just
help me out
thinking.
here.
I was thinking of you know, when you said that shareholders don't have much voice in the direction of what the corporation would do, and so I agree with Professor Joel that I would not want to wait for the shareholders to opine on whether or not some particular candidate was endorsed by the CEO or by the company. Part of the structure of that is that when you buy, if you work at that company, if you're a shareholder in that company, then you have some trust in the leadership of that company. If it's not, I mean, the board can move them out of the way if they're not performing. The same would hold true with a union. You talk to any union member. The shop steward or the president of the AFL-CIO or Unite HERE doesn't go to every person who works in our facility and say, you know, do you like candidate X or Y? You know, those decisions are made pretty much the same way that corporate endorsements are made in a PAC. It's pretty much the same thing. So there's not any real egalitarian wonder world out here that is so much different when organizations make those political endorsements or political decisions. It's pretty much done the same way.
I wanna
In
know,
any
that-
organization.
That's not self-governance, right? That's elite
That's the point.
democracy, right?
Yeah.
That's the, and that's one of the things you have to specify. This is good for democracy. Which version of democracy is
Well, it
it
depends
supposedly
on- yeah,
good for?
but, I mean, it
I want to
gives
think
them
that
to
the
be a
thing
moral
about the
judgment,
shareholder
too.
vote, it's worse than we're making it out. Because, I mean, Linda's certainly, I don't agree on the prior restraint point. But we don't have enough time to debate that. We can argue about it over dinner. But Linda's certainly right that shareholders don't have much control. It's a fiction that they're shareholders own the corporation,
people don't
and we've known that since Burley and Means in the 1930s. But it's worse than that, right? So imagine I own a stock of BP, and I'm in favor of offshore drilling. So I make a proxy, right, motion to have BP take out ads in favor of offshore drilling. Right now, I'm probably in good shape. The management's probably going to like me. Probably a lot of other shareholders are going to agree with me, so I'll probably be able to get the votes. That's neither here nor there. Now imagine the opposite. I have a share in BP, and I'm against offshore drilling. And I want to have the board endorse or take out an ad against offshore drilling, or in 4 candidates who oppose offshore drilling. They're going to say, oh, we can't do that. That violates our obligation to the shareholders. That would violate Ford versus Dodge. Our fiduciary obligation to the shareholders is to make as much money for them as we can. So, sorry, not only do we not agree with you, but it would be against the law for us to fight. Right? So it's not democracy at all, right? It's not just that the corporations have a lot of money or just that they're creatures of law. They're particular kinds of creatures. Right? They're monomaniacs. That's the point, right? They're not real people. They're very special purpose institutions. They're institutions for making money. They're great at that. And that's not necessarily a bad thing. We're a richer society because of that. But it has lots of bad consequences, and especially if you let them into the political arena.
Well, but sometimes in order to protect the ability and the interest of the shareholders, the employees and all to make money, they have to be able to lobby the public on different kinds of issues. So if they have the right to do that and they can lobby about laws, why can't they lobby about lawmakers?
I don't know, I'm not sure. I'm actually, this sounds more radical than I know you'd be comfortable with, but the shareholders could do the lobbying.
Right,
So,
The corporate
well,
officers can do the lobbying. You don't need GM to do the
right,
lobbying.
you don't.
Right.
Right? I mean, that goes to the,
See,
it's
I-
the speech and not the speaker.
and I-
The speech is going to be there.
And I agree with you. Namely, from your point of view, you can regulate lobbying expenditures just as easy as you
Well,
can regulate
I use
campaign
lobbying,
expenditures.
I
Well,
didn't mean to be precise.
Okay.
I mean, the political speech, right? If we're against candidate X because he's going to ruin the auto industry, there are enough people who work at GM and Chrysler, not as many as there used to be, obviously, a dwindling number, enough people who are invested in them that they're, I mean, Dingell's been doing this for decades, right? That's
Well,
Korea.
I think we can't decide this issue of lobbying and corporate role tonight, but thank you so much, both of you, all 3 of you, for your contributions tonight. It's been very helpful to understand the perspective of corporations and the academic perspective, sort of the 2 sides of this issue.